but to relieve your agony, you don't have to sit in here for 2 hours or so to listen to us reading out the judgment. Instead, we have prepared a synopsis of the judgment, which is basically a summary, which I'm going to read from, which is not as long as the judgment itself. So it reads as follows. This is a short synopsis of the judgment of the court, focusing on the principal issues raised and the court's findings and conclusion. The full judgment will be available to the parties and the media after this summary has been read, together with this summary. These proceedings concern a challenge to the 2024 presidential election brought directly to this court, exercising its first instance jurisdiction under the Electoral Act number 14 of 2014, which I shall refer to as the Act. The President had, in September 2024, set a date for the conduct of the 7th presidential election under Section 64 of the Act. That set date was the 27th of November 2024, from 07 hours to 21 hours. Earlier in 2024, the Electoral Commission of Namibia, or ECN, had a registration drive that resulted in 1,449,569 voters being registered to vote in the election. A total of 1,611,000 ballot papers were also printed, 10% more than the total registered voters. On the 27th of November, the electorate went to the polls to elect a president. Both the Independent Patriots for Change, IPC, and the Landless People's Movement, LPM, registered political parties which had both fielded presidential candidates, expressed dissatisfaction to the ECN concerning the election. Both voiced concern at the lack of and unavailability of ballot papers and called upon the ECN to address this and other concerns raised. The LPM proposed that the President extend the voting period to 1400 hours on the 28th of November 2024, and the ECN at 22:57 hours on the 27th of November 2024 issued a directive that all polling stations remained open after 21 hours because of a shortage of ballot papers, so that all eligible voters in queues by 21 hours could exercise their right to vote. The ECN took legal advice from the Attorney General, in short the AG, concerning ballot shortages. The advice concluded that the ECN should approach the President to extend the voting period determined by proclamation in September 2024. The ECN on the 28th of November 2024 resolved to recommend to the President to extend the voting to 29th and the 30th of November to enable voters to vote on those days at polling stations where ballot shortages were experienced. The President, acting on the advice of the Attorney General and Independent Senior Counsel, proceeded to issue Proclamation 34 of 2024, which extended the period of voting from 21 hours on the 27th of November to the 30th of November 2024 at 36 polling stations listed in the schedule to that proclamation. Polling proceeded at the 36 listed polling stations on the 29th and the 30th of November 2024. A total of 9,805 votes were cast over the extended period, whilst 1,089,777 votes were cast on the 27th of November 2024. On 3rd of December 2024, The ECN chairperson announced the results with the seventh respondent, Dr. Nandi-Ndaitwah, obtaining 58.07% of the total votes, and Dr. Itula securing 25.84%, and Mr. Swartboy 4.65%. On the 27th of December 2024, Dr. Itula launched these proceedings, seeking an order that Proclamation 36 is unconstitutional and in violation of the Act and therefore invalid. Dr. Itula also alleged irregularities with regard to the verification tablets causing delays and concerning voting and counting. Dr. Itula also raised other irregularities, including the alleged unlawful establishment of new polling stations in the impugned proclamation. He sought to have the election's results set aside and a fresh presidential election held. On the 6th of January 2025, LPM and Mr. Swartboy applied to join the challenge as co-applicants. Central to their case is their contention that Proclamation 34 is ultra-virus, beyond the powers of the President, and invalid for that reason. They called for the annulment of the votes cast beyond 27th November 2024, maintaining that those votes were taken under an unconstitutional extension. They also asserted that the ECN decision to recommend the extension was improperly influenced by the executive, particularly the Attorney General and the Minister of Presidential Affairs. They also alleged that the selective nature of the extension was actuated by political bias and amounted to a manipulation of the electoral process. They also contended that the President acted in bad faith to favor his own political party. LPM and Mr. Swartboy, instead of following Rule 7, Sub-Rule 17 of this Court's Presidential Election Dispute Resolution rules, so as to become co-applicants, instead applied for joinder as applicants under Rule 10. The respondents also opposed this application. The respondents meaning the President, ECN, SWAPO Party, and Dr. Nandi-Ndaitwah. They objected to the joint application of LPN and Mr. Swartboy. As we stated fully in the judgment, to uphold that objection would be to place form above substance. The joint application sets out the relief sought and the basis upon which it is sought. All the respondents fully traverse the factual and legal contentions advanced by the LPM and Mr. Swartboy. They sustained no substantial prejudice. LPN and Mr. Swartboy introduced an important dimension to this case, which sought to be properly ventilated and addressed in an authoritative judgment of this Court in the public interest. In the exercise of this Court's inherent jurisdiction, LPM and Mr. Swartboy's joint application is accordingly allowed. Both sets of applicants raised several allegations of irregularities concerning their conduct of voting and counting and directed the ECN Directive of 27 of November 2024. In respect of those allegations, the respondents relied on Section 204 of the Electoral Act, which requires the presence of an occurrence book at every polling station in which all complaints or events in which a person is satisfied are to be recorded. If an event or complaint is not recorded in the OB or the occurrence book, any event of complaint is deemed not to have occurred. No events or complaints were so recorded. The applicants in any event did not provide specific evidence in support of the several of the allegations, as we point out in detail in our judgment. In accordance with the well-established principles, this Court requires that founding affidavits must contain clear and precise averments so that respondents are aware of the case they must meet. The lack of clarity in the founding papers undermines the claims made, and the ECN's denials were not challenged in reply. One example of this was the sparse allegation and the lack of specificity concerning allegedly new polling stations made by Dr. Itula. That was met by a detailed answer by the ECN inviting specificity in reply, which was not forthcoming. The defining features of the applicant's remaining case in support of the challenge to the election are therefore as follows. A, the ECN and the President had no power under the scheme of the Electoral Act to extend the period of voting. B, the ECN and the President selected for extended voting polling stations, which are in the ruling party's strongholds. C, the President and ECN discriminated against voters from constituencies not forming part of the selected 36 polling stations, and in that way disenfranchised certain voters. D, the election was marred by the AG and the Minister of Presidential Affairs unconstitutional conduct. E, having once exercised the power under Section 64(1)(b), the ECN and the President became functus officio and could not re-exercise that power. And finally, F, in Proclamation 36 of 2024, the President purported to act in terms of Section 641(b), and having done so, could not in reply assert that he had implied power to do so by virtue of Article 31(1) of the Constitution and Section 9 of the Interpretation Ordinance 37 of 1920. At the heart of these remaining complaints is the question whether the President had the power on the recommendation of the ECN to extend the voting in the manner that he did. It is necessary, therefore, to first address that threshold question. If the President was so empowered on a proper construction of in particular, Section 64 of the Electoral Act, the only issue that remains is whether it was permissible for the proclamation, or rather for Proclamation 34 of 2024, to restrict the voting to the selected 36 polling stations or constituencies. It bears repeating that the core of the present dispute is a virus of the Proclamation 34 of 2024. But there are a raft of peripheral issues which need to be resolved first. They are dealt with in detail in the judgment, but for the purposes of today's proceedings, we will briefly refer to those in this synopsis. These include the alleged retroactivity of Proclamation 34. On the applicable test in motion proceedings, we found that, barring the identified 36 polling stations, polling stopped in the remaining 4,663 polling stations at 2100 hours on the 27th of November 2024, save for the polling mandated by Section 93, subsection 3 of the Electoral Act. In the latter respect, in terms of the law, there is no time limit for the completion of such polling. The 4,663 polling stations that remained open did so for the purpose of transferring ballot paper books to the 36 polling stations. As regards the 36 polling stations, we must accept the ECN's version that at the close of the polls at 2100 hours on the 27th of November 2024, ballot papers had run out. It is stating the obvious that no poll could take place or could be taken in the absence of ballot papers. The ECN's version, which prevails, is that the 36 polling stations remained open for the purpose of receiving ballot papers from those polling stations that had excess ballot papers. The transfer of ballot papers, therefore, occurred on the 28th of November 2024. On the established facts, the real objective the ECN and the President were pursuing was to make it possible for voters who could not vote at the 36 polling stations to be able to do so. That is apparent from the fact that the ECN met at 1000 hours on the 28th of November and passed a resolution to recommend extension to the President. The President then issued the proclamation on the 28th of November based on that recommendation. The legal effect of the impugned proclamation, therefore, was not to validate the Section 33, subsection 3 voting, but to extend the right to vote to those who could not because ballot papers ran out at certain polling stations. We move on then to the next peripheral issue, that is of restricting voting to 36 polling stations. As to the allegation that it was discriminatory to extend the voting to only some polling stations, the uncontested evidence from the ECN was that ballot papers ran out at the identified polling stations, as already observed. Another nuance to Dr. Itula's complaint about voting being limited to 36 polling stations was that the measure was per se discriminatory and therefore unlawful. In the first place, discrimination cannot arise because the President was not dealing with a situation where ballot papers had run out in all the 4,699 polling stations. It is clear from the evidence that the measure was intended to place voters who presented themselves at the 36 polling stations, and where that the extension of voting only to the 36 polling stations was not inherent SWAPO. On the assumption, an issue to which we will turn in due course, that the President had 36 polling stations to the exclusion of the remaining polling stations was aimed at achieving and was related to a legitimate public objective of enfranchising voters. Most of the judgment of this court are misplaced. The doctrine of functus officio is inapplicable to the exercise of power granted under Section 64, which amounts to a legislative administrative power. That power is capable of being reconsidered if it is in the public interest to do so, and if it does not take away vested rights created by the previous decision. The Mosted case is distinguishable in principle on the basis that what was involved there was not the exercise of a legislative power. Now we move on to the crucial question, and that is whether the President had the power to extend the period for voting. Having disposed of the peripheral issues, what is left is to consider whether, on a proper construction of its provisions, the Electoral Act grants a power for extension of the voting period determined by the President in terms of Section 64, subsection 1b. The applicants refute the existence of a power to extend the voting, while the respondents, in particular the President, argue in favor of the existence of such a power and locate it in Article 32(1) of the Constitution, Section 9 of the Interpretation of Laws Proclamation 37 of 1920, and Section 1, subsection 2 of the Electoral Act. According to Article 32(1) of the Constitution, I quote, "As the head of state, the President shall uphold, protect, and defend the Constitution as the supreme law, and shall perform with dignity and leadership all acts necessary, expedient, reasonable, and incidental to the discharge of the executive functions of the government, subject to the overriding terms of this Constitution and the laws of Namibia, which he or she is constitutionally obliged to protect, to administer, and to execute." The President also raises Section 1, subsection 2 of the Electoral Act, which states, and I quote, "A person interpreting or applying this act must, A, do so in a manner that gives effect to the rights, freedoms, and responsibilities in the Namibian Constitution, and B, take into account the Bill of Fundamental Voters' Rights and Duties and any other appropriate law," end of the quotation. Crucially, the respondents rely on Section 9 of the Interpretation of Laws Proclamation for the proposition that the President had the power to extend the polling station, or the polling period, I should say, as he did in terms of the impugned proclamation because occasion required that he did so. Section 9.1 of the Interpretation of Laws Proclamation provides, when a law confers a power or imposes a duty, then, unless a contrary intention appears, the power may be exercised and the duty shall be performed from time to time as occasion requires. And this is the operating word, or these are the operating words, as occasion requires. For their part, the applicants argue that the reliance on Article 32.1 is misplaced. First, because it's not an empowering provision, and secondly, because even on its own terms, the article makes clear that it's subject not only to other provisions of the Constitution, but also to other laws. The interpretation preferred by the applicants is underpinned by the notion that the intention of the legislature was to invalidate an election which is not completed within the time stipulated in Section 64. To test the soundness of that approach, it's important to appreciate what, to a large extent, led to the difficulties experienced on polling day. The Electoral Act permits a voter to vote at any polling station and not necessarily at a polling station in the constituency where he or she is registered as a voter. For the presidential election, there were potentially 1,611,000 voters and 4,699 polling stations. ECN had printed only 10% excess ballot papers as a contingency. It is a practical impossibility for the ECN to have known in advance how many voters would turn up at a particular polling station on a polling day and to distribute the ballot papers in a way that there would be a sufficient number of ballot papers at a particular polling station. Moreover, such an exercise would have been impossible with the election administrators prescribing to voters where they should vote in order that their distribution of ballot papers is not thrown out of balance. If they turned away voters not registered in the constituency, in preference to the voters registered at the polling station, that of course would have been an irregularity. Another feature of the election process that caused delay at the polling stations was the malfunctioning of the electronic verification tablets and loss of battery power in the devices used to examine voters' fingers for the indelible ink. Although not prescribed by the Electoral Act, the ECN explained that it decided on their use, but the applicants do not identify them, and no reliance is placed on specific human failures affecting the integrity of the election. In the absence of admissible evidence that the ECN's lack of proper planning caused the problems experienced on polling day, it is an open question whether the ECN could have done better preparation. The upshot of it all is that, in substantial part, the delays experienced at the polls were the result of the legal framework governing elections in Namibia, particularly the presidential elections. Against that backdrop, the question arises whether the Electoral Act should, as proposed by the applicants, be interpreted that there exists no power in the ECN and the President to re-exercise their power to extend the polling period. To uphold the applicant's contention that the Electoral Act contains a contrary intention, that the power in Section 64(1)(b) may not be re-exercised, it must be clear from that Act that once exercised, the power is exhausted and requires, such as presented itself on polling day on the 27th of November 2024. The first obstacle in the way of the applicants is Section 1(2) of the Electoral Act, which, as we observed, requires that when interpreting it, the court must do so in a manner that gives effect to the fundamental right to vote. I beg your pardon. For interpretation purposes, Section 1(2) of the Electoral Act is a new provision which did not exist under the Electoral Act 24 of 1992. It's a fundamental canon of construction that the legislature does not use meaningless language or words in a statute. Section 9(1) and Section 9, subsection 1 and 3 of the Interpretation of Laws Proclamation must therefore be seen in that light. if regard is had to the words "as occasion requires" and "unless the contrary appears in other legislation." The implementation role assumes significance in the circumstances such as that which faced the ECN and the President, where ballot papers had run out at specific places, and there existed a solution to the problem capable of promoting the right to vote. The interpretation function resting on the court requires of it to interpret provisions of the Electoral Act in a way that promotes the right to vote, and to do so in a manner that allows the implementers to take all such measures as are within a range of reasonable and rational options open to them to promote and protect the right to vote. The interpretation put forward by the applicants is underpinned by the notion that completion of voting within the time determined for the conduct of the poll is so important a principle that it trumps an opportunity as possible to extend the franchise to the greatest number of eligible voters. That approach is in sharp contrast to Section 1, subsection 2 of the Electoral Act. The demerit of that interpretation is that it approaches Section 64(1)(b) as if it imports an intrinsically immutable value in the period determined for voting. In other words, that the legislature intended that if the period determined for voting cannot be complied with, the objective of a free and a fair election is irreversibly compromised. A fresh election will cure the defect and satisfy the objective of a free and a fair election. Undoubtedly, in our view, different considerations must apply where the exercise of a power is in the furtherance of the right to vote, as opposed to limiting or restricting it. The applicants concerned that an implied power to extend voting will give carte blanche to the President to extend voting to benefit himself or herself in circumstances where he or she is also a candidate is assuaged by the fact that the power to extend is subject to the recommendation of the ECN. The President has no power to extend voting on his or of his or her own accord. Moreover, each case is decided on its own unique facts. If the President were to extend voting to benefit him or herself, it's arguable that such a decision would withstand challenge. To visit with nullity a failure to complete an election within the time stipulated under Section 64 of the Electoral Act, in the absence of proof that non-completion denied eligible voters their right to vote, is out of all proportion to any public benefit or legitimate public benefit to be derived from inferring a nullity. By stronger reasoning, to deny the existence of a power to extend voting to afford eligible voters the right to vote in circumstances such as faced by the Electoral Commission on the 27th of November 2024 serves no legitimate public purpose. We discern no compelling public policy considerations from the Electoral Act why an election must be vitiated without affording the ECN and the President the opportunity to re-exercise the power under Section 64(1)(b), quote, from time to time in order to promote and protect the right to vote, quote, when occasion requires. It could not have been within the contemplation of Parliament that if voting is not completed on the date determined in terms of Section 64(1)(b) of the Electoral Act, that would be a complete failure of a free and a fair election, and that the only remedy is a fresh election. Such an interpretation would produce, in our respective view, an absurd result. In the absence of an expressly granted power, whether a power can be implied or not is a function of interpretation. A unique feature of the Electoral Act is that it instructs the court as an interpreter to give preeminence to the right to vote. That has two consequences. The first is that the Electoral Act must be so interpreted that a power exercisable under the Act should advance and not limit the right to vote. Secondly, the power must not be exercised so as to deny the franchise to some while facilitating it to others. That raises the strong inference of an implied power of extension of the voting period from time to time when the occasion requires. Reliance on the Puma judgment of this court, therefore, does not assist the applicants, and the fuller reasons are given in the judgment. For all the reasons set out above, we are satisfied that the ECN was competent to recommend, and the President had the power to re-exercise the power granted in Section 64(1)(b) as the occasion required to make it possible for voters who would otherwise be disenfranchised to vote on the 29th and the 30th of November 2024. That extension did not amount to establishing new polling dates and a new election. It was a continuation and a completion of the election which was determined on the 26th of September 2024. The conclusion we come to is that Proclamation 34 of 2024 was lawfully enacted, and the voting that occurred on the 29th and the 30th of November 2024 was valid and lawful. The applicants have therefore not made out a case for the invalidation of the impugned proclamation. Their challenge to the outcome of the 2024 presidential election therefore fails. As far as the costs are concerned, we apply the principle that where a litigant seeks to ventilate constitutional complaints against the state or its organs, it should not be marked in cost if unsuccessful. It must be apparent from the judgment that many of the issues raised are not only novel in our electoral jurisprudence, but raise important issues about the exercise of public power, especially in our pluralist multi-party democracy. The court has had the opportunity to clarify important issues, which no doubt will assist functionaries who conduct elections in the future. That would not have been possible had the applicants not brought the challenge. For all the reasons fully given in the judgment, it would have a chilling effect if we order costs. Although they are unsuccessful, as the judgment demonstrates, the applicant's case on the virus of the impugned proclamation was an arguable one. We are satisfied, therefore, that in the exercise of the court's discretion, that this is not a proper case to order costs against the unsuccessful applicants, and that each party should bear their own costs. The proposed order is therefore as follows. A, the Landless People's Movement and Mr. Bernardus Swardboy are joined as second and third applicants, respectively. B, the first, second, and third applicants' applications are dismissed. And C, there is no order of costs, and each party must bear its own costs.
I agree.
I agree.
I agree.
I agree.
Now, this is a judgment of the court, which I now have the pleasure of handing down. And that concludes today's proceedings. The court will now adjourn.